Hi, I'm Karl Konrad and welcome back to Australian Immigration News for our 2025 editions. With 313 videos under our belt in the last 4.5 years and nearly 10 million views, you can feel confident that you have found Australia's most reliable and sought-after immigration news channel. The company I founded more than 26 years ago, Australian Immigration Law Services, pays to produce these programs. After 26 years of running a professional practice and encountering nearly every possible complicated legal immigration scenario, our viewers gain the benefit of one of Australia's most experienced businesses. This year will be another busy one, so make sure you subscribe to ensure you don't miss out on what's happening in the world of Australian immigration. Tonight there are no legal changes to report on. However, that did not stop the student visa cap Ministerial Direction 111 from stealing the media limelight. An article in the Australian Financial Review highlighted that despite the Labor Party's desire to crush international student numbers, a record number of international students are expected to enrol into Australian universities. Of course, that does not mean Ministerial Direction 111 will not have the desired effect in the future, but it will take the whole year before it has any real impact on student numbers. By then, we may have a new change of government and a completely new strategy. In the meantime, the government has rejected a record number of student visa applications for those already in Australia. This can be seen by the new Administrative Review Tribunal releasing its statistics since they opened their doors mid-October last year until the end of November. Their published figures show a record number of 3,557 reviews of student visa refusals were lodged for that single month-and-a-half period. This data also demonstrates that 67% of review applications were successful and their file was returned to the Immigration Department for further processing. Just 16% of the applications to the ART were unsuccessful and another 16% of applicants gave up and withdrew. That means that nearly 70% of the cases, the Immigration Department failed these applicants in making fair and just decisions. Another fascinating figure demonstrates that at the end of November last year, there were still 21,471 student visa review applications yet to be dealt with. Given that only 313 cases of student visa appeals were finalized in the 1.5 months, let's say about 200 for 1 month, it will take about 107 months to get through the current backlog. That is an astonishing 8.9 years. We expect that the extra staff promised to the ART will shorten that time frame, but it could still mean a student visa review application will have a very long time to wait. Now, for some, that long waiting time may be a significant advantage. However, remember that to be one of those nearly 70% successful applicants in a student visa appeal, you must convince the ART member that you are still a genuine student. This could be difficult if you have finished your course or courses, so why do you still need a student visa again? And speaking about the ART, it was unusual to see in the Australian newspaper this week a report on how a federal court judge chastised a ART member for simply copying and pasting the Immigration Department's reason for cancelling a visa. The article reads, "A federal circuit and family court judge has slammed the Administrative Appeals Tribunal for copying and pasting the reasons of the Immigration Minister's delegate when affirming a decision to strip an Indian immigrant of his student visa, saying that the tribunal failed to bring its own independent mind to the review." So when you go to the tribunal and appeal an Immigration Department's decision, the ART member is meant to keep an open and independent mind to your case. So if they just copy and paste the original Immigration Department's decision into their own decision, this may indicate they have not assessed your application fairly. You could then take the case to the federal court on this basis and have a reasonable chance of overturning the ART decision, as it happened and was reported about in this article. Firstly, thank you all so much who send in messages and questions to our channel, and this year we will make a concerted effort to get back to all comments. Tonight we will answer a few questions you have sent in regarding the changes to the 482 and 186 Employer Nomination Scheme visas. The first one I will cover is one that someone asked me during a consultation, and it's a good one. For the ENS direct entry stream of the 186 visa, does the business have to wait for the visa applicant to reach the 3-year work experience requirement before they can lodge the company nomination process? The answer is no, they don't have to wait. The nominations can be lodged for the direct entry and TRT streams of the 186 visa before the nominee reaches their work experience requirements. The work experience prerequisites are in the visa application requirements, not the nomination conditions. The benefit of doing this is that a prior ENS business nomination approval can give more confidence to visa applicants before they lodge their visas. But keep in mind that when the nomination is approved, the visa application must go in within 6 months of the nomination approval. And a question from our channel. Thanks for your videos and valuable information, Karl. Could you please cover in your next video about going from the 482 visa to the 186 direct entry before becoming eligible for the TRT? I mean, not finished 2 years of the 482 visa. Can they be eligible for the 186 direct entry early if they have 3 years of experience? In this case, yes, you can apply for the direct entry stream as long as you have the positive skill assessment and the 3 years of experience as the direct entry stream requires. This means that you do not have to wait to meet the TRT requirements as long as you already meet the direct entry 186 requirements. And the next question, hope you can discuss more details on the SID specialist visa and if there will be any age concession for this visa. Also, if someone who has been with one company on the 482 visa for more than 5 years is eligible for the 186 PR age concession, considering he arrived in Australia at the age of 44. For the 186 visas in both the TRT and direct entry streams, applicants must be under 45 years of age. There are several exemptions available for this age requirement, however, and one is the high income salary threshold exemption, which you can find information about on the department's website. However, there is no age exemption alone on the basis of receiving the 482 visa under the specialist stream, and also unfortunately not because you started in Australia on the 482 visa before you turned 45. And in another question, hope you can cover the 186 TRT stream and if you could clarify whether the nominating sponsor has to be an approved SBS employer, please. Since the TRT stream requires that the visa applicant to work for the sponsoring employer on the 482 or one of the old 457 visas, it is natural that the sponsoring employer would have had prior SBS and nomination approvals. Now we will be making detailed videos about the 482 Skills in Demand visa along with the Employer Nomination Scheme 186 visa, hopefully in the coming month. There have been no significant law changes so far this January, but I'm sure they're gearing up to do so as much as they can before the next election is called. As always, if you need help, we are always here. You can book an appointment online, or if you're in a hurry, just pick up the phone. Next week we'll be discussing processing updates and how the system works. As always, take care out there and I'll see you next time. So bye for now.